Hello and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to the first episode of The Nuanced, an initiative where we present a nuanced understanding of complex topics. The year was 2018. The Government of India announced an electoral bond scheme, which was yet another way of donating money to political parties, yet another method of making voluntary financial contributions to political parties. This electoral bond scheme was challenged in the Supreme Court, and after 6 long years, a 5-judge constitution bench of the Supreme Court has declared that electoral bond scheme is unconstitutional. Why? Because it violates Article 19(1)(a) of the Constitution. Also because it is manifestly arbitrary, violating free and fair elections, therefore violating Article 14 of the Constitution. In this lecture, let us look at all that you need to know regarding electoral bond scheme and the judgment of the Supreme Court in a case known as Association for Democratic Reforms versus Union of India. But before we do that, I urge you to press the like button if you are going to like this video and subscribe to our YouTube channel if the content on these platforms is aiding your CSC preparation. Let's get started and look at, first up, what is a political party? Political party is a group of individuals whose primary objective is to capture political power. A group of individuals who contest elections and through democratic means, through legitimate means, form the government and capture political power. Such an entity is a political party. And this political party needs funds. Why? Because it wants to pay salary to its office bearers. It needs money so as to campaign for the elections. It needs money to propagate its ideology. And funding of these political parties is also important if we have to ensure free and fair elections. How? Listen to me carefully. The money raised by political parties through voluntary donations, through financial contributions. These political parties, they use this money to give funds to its candidates who may belong to SC community, who may belong to ST community, who may be from poor, marginalized, weaker sections of the society. So the money raised by political parties through these political donations, through these financial contributions, this money is used by political party to allow its candidates to campaign in the elections, to contest elections. If this is not allowed, then the entire electoral process would be open to those who are wealthy from affluent sections of the society, because they have the money to contest elections. Because let's not forget that elections is a costly affair in India. It requires money for transportation, for boarding, for lodging, for food, for various other purposes, for printing manifesto, for stationery, so many other items for which you need money. And if this political donation is not allowed, then we are leaving this electoral battle to wealthy, affluent sections of the society, which would violate free and fair elections, which you would know is part of the basic structure of Indian Constitution. So political parties need money, need funding, but this money should be clean. This money should be accounted money. This money should not be illicit or what is famously known as black money. And cash is normally associated with black money. So any initiative or every initiative which limits the cash involvement in political donations is a welcome step. And that's precisely the reason the year was 2017. The then Union Minister for Finance, Mr. Arun Jaitley, presented the budget, and one chapter in that budget was transparency in electoral funding. The principal objective of the government was we have to limit the amount of cash donations to political parties. How? Let me give you an illustration. If this is an entity A, B, or C, and they want to donate money to a political party X, any contribution less than 20,000 rupees, there is no need to disclose the identity of the donor. So if there are entities who are donating money to political parties, if political parties are receiving less than 20,000 donation from such entities, you don't need to disclose the identity of the donor. But if this political entity receives more than 20,000 as donations, the political party shall disclose the donor. But then, political parties have to communicate to Election Commission of India, to income tax authorities, what is the amount of money that they donated. And what is the amount of money that they donated from unaccounted sources? And what is the amount of money that they donated, that they received from the accounted contributions? Because any contribution less than 20,000, you don't need to disclose the identity of the donor. And any contribution more than 20,000, you have to disclose. So political parties have to disclose who are these individuals who donated more than 20,000 to political parties. But when political parties submit these details, political parties such as the BSP says that we have received 100% of our contribution from donations less than 20,000. Samajwadi Party says we have received 95% of our donations from less than 20,000. And same is the case with the two biggest national political parties, the Congress and the BJP. They say 60 to 70% of our donations we have received from contributions less than 20,000. But how is it possible? According to various experts, these political parties, they receive donations in the range of 10 crore, 1 crore, 5 crore. But what they do, they basically collect these donations, hire chartered accountants, and divide those donations into receipts of 19,999 or lesser. So these political parties, they receive donations in the form of cash, about 1 crore, about 2 crore, about 20,000. But just so that they don't need to disclose the identity of these donors, what they do, they hire the chartered accountants, they break these donations into receipts of less than 19,999 so that they don't have to disclose the identity of the donor. And Mr. Arun Jaitley said, we need to kill this structure. And for that, let's do something. Let's involve electoral bonds. And what are these electoral bonds? Listen to me carefully. I'll try and make it as simple as possible for you to understand. For example, here is an entity A. It wants to donate money to a political party. Now this entity A, it can be either an individual, a company, a Hindu undivided family. If this individual contributor has to donate money to a political party, what this contributor has to do? Approach the State Bank of India and buy these electoral bonds. But how do you buy these electoral bonds? In the form of check, in the form of demand draft, in the form of electronic transaction. That means you cannot buy these electoral bonds using cash, which means cash is eliminated from political funding. This entity, which can be an individual, can be a corporate entity, can be a Hindu undivided family, approaches the State Bank of India, purchases these electoral bonds. What is the denomination? You can purchase it for 1,000 rupees or 10,000 rupees or 1 lakh rupees or 10 lakh rupees or 1 crore rupees. But there is no limit. Limit in the sense that this entity can buy as many electoral bonds. Multiple times you can buy 1 crore worth of electoral bonds from the State Bank of India, but not using cash, through using check, demand draft or electronic transaction, and purchase these electoral bonds and give it to the political party. And now this political party, it has 15 days to encash these electoral bonds. 15 days to encash these electoral bonds. If not, then this money goes to Prime Minister's National Relief Fund. Long story short, if we need to find an alternative to cash, for that a scheme was conceptualized in 2018 known as Electoral Bond Scheme, where an individual, if you want to contribute, if you want to donate money to a political party, approach the State Bank of India, buy these electoral bonds. By buying these electoral bonds worth 1,000, 10,000, 1 lakh, 10 lakh, 1 crore, you can deposit this into the bank account of a political party, and political party has 15 days to encash this bond, encash this money, or else the money goes to Prime Minister's National Relief Fund. But can every political party raise money through electoral bonds? No. Only those political parties which are registered under Section 29 capital A of the Representation of the People Act, and those which have polled not less than 1% of the total votes. I have a political party. I contested Lok Sabha elections or Legislative Assembly elections. But in these elections, I polled less than 1% of the votes. I am not eligible to raise money through electoral bonds. Only those political parties registered with the Election Commission of India under Section 29 capital A of the Representation of the People Act 1951, which have polled not less than 1% of the total votes, they are eligible to raise money through electoral bonds. But then you would ask, what is the problem? The problem is that these electoral bonds are bearer bonds. These are in the form of promissory notes. And this entire process lacks transparency. This entire process is opaque. Because who is this donor is anonymous. Nobody gets to know exactly who is this donor donating money to a political party. Which various petitions were filed in the court, which basically said that these electoral bonds, they violate the citizens' right to know, which is a fundamental right under Article 19(1)(a), and therefore should be declared unconstitutional. But not just these electoral bonds. In response to the electoral bonds, in preparation towards these electoral bonds, various other laws were also amended during this 2017 Union Budget. When the Finance Act was passed in 2017, changes were made to various other laws as well. For example, Income Tax Act was amended, Representation of the People Act was amended, the Companies Act was amended. And we have to look at electoral bonds along with these changes which were made to these laws. One such change was to Section 29 capital C of the Representation of the People Act 1951. Declaration of donation received by political parties. I told you, any donation to a political party, if it is less than 20,000 worth of donation, the political party need not disclose the identity of this donor. But if this donation is more than 20,000, you need to disclose the identity of the donor. But the point is that electoral bonds can be purchased in 1 crore as well, 10 lakh as well, 1 lakh as well. That means in excess of 20,000. An amendment was made to Representation of the People Act by the Finance Act of 2017, saying this provision shall not apply to electoral bonds. That means through cash, through any other transaction, if a political party is receiving donation of more than 20,000, disclose the identity of that donor. But if you are receiving donation in excess of 20,000 through electoral bonds, you don't have to disclose the identity of this donor. The entire process is anonymous. That's change number one. Change number two, to the Companies Act, to Section 182, Clause 1 of the Companies Act of 2013. Prior to this amendment in 2017, can a company donate money to a political party? Yes. But can it be a government company? No. Why government companies cannot donate money to political parties? I'll tell you slightly later. Any company, except if it is a government company, except a company which has been in existence for less than 3 financial years, any company except a government company and a company which is in existence for less than 3 financial years, it may contribute money to a political party, either directly or indirectly. I will explain what is this indirect contribution, but bear with me for a minute. A company other than a government company or a company which has been in existence for less than 3 financial years, this company can donate money to a political party, either directly or indirectly. But there was a limit. The limit was exactly how much money can you donate to a political party. The limit was you cannot donate in excess of 7.5% of your profits in the last 3 years. Whatever aggregate profit you have generated in the last 3 years, you cannot contribute, you cannot donate more than 7.5% of those profits to a political party. That was the limit. And this limit was removed by the Finance Act. When the Finance Act was passed in 2017, which amended the Section 182 Clause 1, this limit has been removed. Now there is no limit to the amount of profit that can be donated to a political party. Not just that. Previously, only a profit-making entity could donate money to a political party. Now even a loss-making company can donate money to a political party. But that's not the only case. I told you these companies can donate money either directly or indirectly. Indirectly how? Through electoral trusts. The UPA government was in power. The year was 2013. What the government did? Government allowed those companies which are registered under the Companies Act of 1956 that if you want, you can donate money to political parties by setting up electoral trusts. Who can contribute to these electoral trusts? Indian citizens, companies in India, but they have to disclose. They have to disclose to which political party they are contributing. And they can contribute through digital transactions, not necessarily through cash. Which basically means that in 2013, the government allowed companies in India. What you can do, you can establish electoral trusts. For example, electoral trusts in India have been set up by Tatas, by Reliance, by Bharti, by Vedanta as well. So if there are individuals, if there are other companies who want to donate money to political parties, they may donate via these electoral trusts, but they have to mention in their profit and loss statement that we are donating money to these political parties. So these companies, under the Companies Act, they can donate money to political parties either directly or indirectly through the electoral trusts. But previously there was a limit to the amount of donation that they can make, which is dependent upon the profit that they have made in the last 3 years. But now that limit has been reduced. A limit has been eradicated, which means even a loss-making entity can donate money to a political party through these electoral bonds. Not just this, another change was made to Income Tax Act. Political parties, they raise contributions, they raise income. Do they have to pay income tax on the money that they have raised? They don't have to. They are exempted from tax if this money is from house property, from other sources, from capital gains, income by way of voluntary contributions that the party receives from individuals. But in 2017, they made a change. The government made a change that any entity, any individual cannot donate money to a political party in excess of 2,000 through cash. So if you want to donate money to a political party, you are an individual, you can donate only up to 2,000 rupees in cash. Above 2,000, you have to donate in the form of check, in the form of electoral bonds, in the form of other clearing systems. Election Commission of India wrote to the government, my dear government, why don't you make two laws compatible with each other? What are these two laws? If on one hand you are saying that under Representation of the People Act, money received, donated to political party by an individual in excess of 2,000, only this is to be reported. Only this donor is to be disclosed. Why don't you make a change here as well that any donation above 2,000 disclose the identity of the donor? So here you should have made the same change that you made to Income Tax Act, where you are saying that donations above 2,000 cannot be in the form of cash, can be in the form of demand draft, can be in the form of other electronic transactions. Make the same change to Representation of the People Act as well, where any contribution by an individual in excess of 2,000 should be disclosed by the political party. Long story short, Electoral Bond Scheme was launched in January 2018 by the Government of India. The principal objective was that clean money, accounted money, should be used to donate money to political parties. But that was not the only intention. The intention was also to protect the privacy of the donor, so that this donor is not victimized, persecuted by government, so that the identity of this donor remains anonymous. And in response to electoral bonds, changes were made to Income Tax Act, Representation of the People's Act, Companies Act, so on and so forth. Now the challenge before the court was, is this electoral bond scheme constitutional? There were two broad questions that the court had to answer. Number one, does non-disclosure of information on voluntary contributions to political parties, does it violate Article 19(1)(a) of the Constitution? Number one. Number two, does unlimited corporate donations to political parties by amending the Companies Act, where there is no limit to the amount of money you can donate, where even loss-making entities can donate money to political parties, does it violate free and fair elections? Does it violate Article 14? Is it manifestly arbitrary? These were the two critical questions before the 5-judge bench of the Supreme Court, headed by Chief Justice of India, Justice Chandrachud. And the Supreme Court today gave a unanimous verdict. A 5-judge bench of the Supreme Court said this electoral bond scheme is unconstitutional. How? Let's understand. The year was 2002. Same non-governmental organization, Association for Democratic Reforms, approached the Supreme Court, asked a question, dear Supreme Court, do we have freedom of speech and expression under Article 19(1)(a) of the Constitution? Supreme Court said, yes, you have the freedom of speech and expression under Article 19(1)(a). ADR asked, does that mean if we have the fundamental right to say whatever we want to say, does that also include that we can ask questions? Supreme Court said, yes, you can ask questions, but to whom do you want to ask questions and why? ADR said we want to ask questions to candidates contesting elections. What sort of questions? What is your educational qualification? How many criminal cases are pending against you? What is the amount of assets in your name and in the name of your spouse? The court said, yes, there is no harm in asking these questions, but what is the purpose of asking these questions? ADR said, we want voters to make an informed choice. I want to buy a coaching subscription to prepare for civil services examination. And there are multiple options available in the market. And I have to choose the best one. How can I choose the best one if I don't have the information? This information is key to make a choice. Whether live classes are provided or not, whether teachers are good or not, you tell us who are the teachers. Will you provide answer writing evaluation practice? Will you provide prelims test series, mains test series? Can we directly interact with the teachers? Do you emphasize on answer writing in your classes? How would you cover current affairs? Give me all this information, then I will make a choice whether I will buy your subscription or someone else's. Similarly, there are candidates contesting elections. How does a voter know who is this candidate who is best suitable for my constituency? I need information. What is the amount of assets in your name in the last election and today, so that I can see whether there is a spike or not? How many criminal cases are pending against you? Because I don't want lawbreakers to become lawmakers. Association for Democratic Reforms approached the Supreme Court in 2002 and said, dear Supreme Court, does Article 19(1)(a) include the voters' right to information so that they can make an informed choice? The Supreme Court said every candidate contesting election has to disclose these answers, has to provide this information to the voter so that the voters can make an informed choice. But now, because of the electoral bond scheme, let's say I am an environmentalist. I believe in environmental conservation. I don't want to vote for a political party who gets donations from a polluter of the environment. Maybe a coal company, maybe a mining company, maybe a company whose track record is that it is the destroyer of forests and environment. But because of electoral bonds, I will never get to know. Because all these donations to political parties through electoral bonds are anonymous. Voters will never know who is donating money to whom. So does it violate voters' right to know under Article 19(1)(a)? That was question number 1 before the Supreme Court. And question number 2, does unlimited contributions, corporate donations to political parties violate free and fair election, violate Article 14 of the Constitution? Let's understand how Supreme Court made this decision to declare electoral bonds unconstitutional. Number 1, does Article 19(1)(a) include information on financial contributions made to political parties? Previously, we were talking about candidates contesting the election, individual candidates contesting the election. So the voters had the right to know the antecedents of candidates contesting the election. Does this right to information also include information on financial contributions to political parties? Because previously the court said, what is the educational qualification of this candidate? Disclose it. How many criminal cases are pending against you? Disclose it. What is the amount of assets in your name and in the name of your spouse? Disclose it. But does this right to information also allow that we need to disclose the financial contributions to political parties? For that, Supreme Court said, our decisions on right to information can be classified into 2 phases. In phase number 1, we focused on the close relationship of open governance and information. Citizens have the duty that you have to hold the government accountable for their actions or inactions. How can you hold the government accountable if this government is not open in its dealings? That is why we need government to open up. We need the government to tell us how you are taking decisions, how you are making decisions, how you are giving contracts to different entities. But Supreme Court said in our phase 2, we don't want RTI, right to information, to be restricted to state affairs only. Because information is required for me to form my views on social issues. I need information to form my views on political issues, on cultural issues. And in India, political parties, they should also come under this disclosure. Why? Because in our setup, individual candidates as well as the parties should come under this setup. Why? Because we place more emphasis on parties rather than candidates. So if individuals are subject to right to information, political parties should also be subject to right to information. Why? Because in our system, political parties have more prominence as against candidates. How? Listen to me carefully. Is there a limit to the amount of money that can be spent by a candidate contesting elections? Yes. Varies from Lok Sabha to Legislative Assembly constituency. Varies from a big constituency to a smaller constituency. So there is a limit. But is there a limit to the amount of money spent by political parties in the election? No. If right to know, right of information, to know the antecedents of a candidate contesting an election is a fundamental right, why don't we add this, apply this to political parties which are much better political entities, which have more prominence in India? How? Of India in the 1960s, symbols are allocated to political parties. So political parties have more prominence in India. Forget about the symbols order. Look at the 10th schedule of the Constitution, which in Shiv Sena verdict, Supreme Court has said the whip issued by a political party is binding on the candidate. This whip cannot be issued by the legislative wing of a political party. This whip is to be issued by the organization of the political party. So political parties have more prominence. And we have our electoral culture as well. Who releases the election manifesto? An independent candidate or a political party? So if political parties have more prominence because of the symbols order, because of the 10th schedule, because of electoral culture by means of printing election manifestos, then we can safely say that this right of information on financial contributions made to political parties, Article 19(1)(a) includes it. Not just this. Supreme Court said funding to political parties is essential. But look at me carefully. But we are in a system of political inequality which is driven by economic inequality. Listen to me carefully. This is the most important point of the verdict. You are donating money to a political party. I am also donating money to a political party. We are ordinary people. But look at the donation given by a corporate entity or a wealthy individual or a bourgeois. There is economic inequality in India. And this economic inequality leads to political inequality, where the rich donor, he gets access to the table of the political party. He gets proximity to the leaders of the political party. And then there is a quid pro quo. Why will a bourgeois, a capitalist entity, a rich individual donate money to a political party? In return for license, in return for permits, in return for policy changes. So there will be policy changes because the political party to which this rich individual has donated has come to power, now is benefiting this particular donor. So there's a quid pro quo, reciprocity. I will donate money to you, Once you come to power, you will have to implement policies that benefit my business. You will have to grant me licenses. You will have to grant me permits. So if funding to political party is essential, but where is this funding coming from? That is even essential. Because there is an element of quid pro quo which we cannot discount. Now the question before the court was, by looking at all these arguments, does electoral bonds infringe upon the right to information of a voter? Because right to information comes under Article 19(1)(a) of the Constitution. But this right to information under Article 19(1)(a), it is not an absolute fundamental right. Reasonable restrictions can be imposed on this fundamental right. There are exceptions to this fundamental right. And all these exceptions are mentioned under Article 19, Clause 2. How many exceptions are there for Article 19(1)(a)? 8 reasonable restrictions. Listen to me carefully. 8 reasonable restrictions. Your 19(1)(a) can be restricted on the grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, morality or decency, contempt of court, defamation, incitement to an offense. Only on these 8 grounds, your Article 19(1)(a) can be restricted. None of these grounds apply to electoral bonds. Do electoral bonds, if we disclose this identity of the donor, does it violate friendly relations with foreign states? No. Does it affect the sovereignty and integrity of India? No. Does it incite people to violence? No. Is it defamatory? No. Is it contempt of court? No. It does not apply to any of the 8 restrictions under Article 19, Clause 2. The government said, but dear Supreme Court, we are implementing electoral bond scheme primarily to curb and eradicate black money. The Supreme Court said, is black money one of the 8 reasonable restrictions under Article 19, Clause 2? Can your right to know be restricted on the grounds that you want to eradicate black money? It's not there. The court said, let's assume for a while that eradicating black money is a legitimate state interest. Let's assume that it is a genuine concern. We need to eradicate black money. But for that, we need to follow and apply the test of proportionality. What is the test of proportionality? Listen to me carefully. There is a mosquito here in this room. I need to kill it. What are the options available with me to kill this mosquito? It may be dengue causing mosquito, Aedes aegypti, whatever it is. I need to kill this mosquito. What are the options? I can use a hit bat, that electric bat, to swatter this fly dead. I may use a Mortein or All Out if it works. I may use those rings if they work. I may even use an AK-47 rifle to fire and suddenly one bullet will hit the mosquito and it dies. Or I may use a bomb. I may use a nuclear missile as well. I may use an atom bomb as well. So what is the purpose? The purpose is to kill the mosquito. But can we allow any way, any method to kill this mosquito? No. We have to allow only the least restrictive means to kill this mosquito. That is what we call least restrictive means test. If through electoral bonds, your purpose is to eradicate black money, even if it is a genuine, legitimate state interest. But for that, do we need to make this entire process opaque and violate the citizens' right to information? Is this the least restrictive way to eradicate black money? The Supreme Court said no, there are other least restrictive ways of eradicating black money. What are these? electoral trust. Eradicate black money if that is your objective by allowing contributions through electoral trusts. In fact, in the last 10 years, close to 2,500 crore has been donated to political parties through electoral trust. But in just 5 years, close to 16,000 crores have been donated to political parties through electoral bonds. And the biggest beneficiary of that is the ruling political party. If the real objective is to eradicate black money, for that we need to apply the test of least restrictive means test. And for that, the other least restrictive ways are electoral trust or any contribution more than 20,000. Don't allow cash. Allow only digital transactions. Paytm karo, if Paytm works now. Right? These are the other least restrictive methods if you want to eradicate black money. We will not allow right to information under Article 19(1)(a) to be violated just because you want to eradicate black money. Why? Because there are other least restrictive methods to eradicate black money, such as electoral trust, such as restricting donations above 20,000 to only electronic transactions. Let's look at something else. One thing that we have now understood. Question number 1. Does electoral bond scheme violate the citizens' right to know about the financial contributions of a political party? Yes. But let's keep political parties aside for a while and let's focus on the donor. I want to donate money to political party, but I want to remain anonymous. Why? Because I have right to privacy, which is a fundamental right guaranteed to me under Article 21 of the Constitution. And that is what K.S. Puttaswamy judgment said in 2017, where a 9-judge unanimous verdict of the Supreme Court was right to privacy is a fundamental right under Article 21. I want to remain anonymous. Why? Because if I am not anonymous, if my contribution to a political party is disclosed, then this political party does not come to power, another political party comes to power. Will it not victimize me by sending enforcement directorate against me, CBI against me, other agencies against me? So I want to donate money to political party, but at the same time, I want to remain anonymous. Why? Because that is an integral facet of my right to privacy. The Supreme Court was surprised looking at this argument, and Supreme Court said, we need to ask 2 questions regarding this. Does right to privacy include right to protect a citizen's political affiliation? I don't want to reveal to anybody what is my political ideology. Does right to privacy protect it? Protect my political affiliation? And if the answer to this question is yes, that our laws have to protect my political affiliation, should that also not include my financial contributions to political party is also part of political affiliation? Don't disclose it either. Because I have right to privacy. Agreed? Yes. Does right to privacy also include right to protect my political affiliation? Supreme Court said yes. Why? Because forming political belief is the first political expression. And that becomes possible if you are affiliated to a political entity. You may not necessarily be a member of a political party, but you favor the ideology of a political party. If this political affiliation of mine is not protected, is not guarded under right to privacy, then do you know what will happen? The state will victimize me. Maybe by denying me employment. If during employment process, the government is advertising posts, inviting applications for government jobs, and thereby the government realizes that this particular candidate who is applying for this post has a political affiliation towards an opposition political party, the government may not recruit, may discriminate against this person. And it has happened. There was an advocate of the Bombay High Court, there was an advocate of the Madras High Court, recommended by the Supreme Court Collegium to Madras High Court, to Bombay High Court. Government said, no, we don't want to appoint them. Why? Because they are sharing articles which are critical of Prime Minister. Why? Because they are making political speeches. So does right to privacy include protecting my political affiliation? Court said yes. We have to protect it. Because if we don't protect it, you may be victimized by the state, first by denying employment or by sending trolls against you. The trolls on Twitter. Not just this. Supreme Court said, look at this political affiliation of an individual. Does this political affiliation, a citizen's political affiliation, is it included as part of the citizen's right to privacy? Court said yes. But at the same time, the court also raised an important issue, raised an important matter. If this political affiliation is not protected under right to privacy, then there can be state surveillance. How state surveillance? Listen to me carefully. I log into, I have an app, Amazon app. I buy a book. Let's say the book is by Karl Marx and Friedrich Engels. So what you can do? You can map my political ideology by looking at my browsing history, saying this person belongs to this particular political ideology. I go to Ajio.com and I buy branded clothes or unbranded clothes. Whether I'm buying branded clothes or unbranded clothes, the state will realize to which class I belong. By subscribing to the e-paper of the Hindu newspaper or by subscribing to the digital version of Economic and Political Weekly, the state will come to know through surveillance, through targeted surveillance, that I belong to the leftist ideology. And then what will happen? The political party in power will use digital marketing techniques to target me because they know I am a supporter of a different ideology. They need to buy my vote. So through influencing, through performance marketing, my right to choose a candidate, my voting behavior will be influenced. Not just voting behavior be influenced. It may also lead to gerrymandering. Gerrymandering in the sense, it is a practice. In England, for example, in other countries, for example, you delimit constituencies in such a manner that it favors the ruling political party. How? A simple example. For example, there are 3 constituencies, A, B, C. If we don't protect the political affiliation under right to privacy, which means there will be surveillance, there can be surveillance, the kind of books that I purchase, the kind of newspapers I subscribe to, the political party will get to know to which ideology I belong, and then targeted ads will be displayed on my profile so that my voting behavior is altered. Or people from this particular constituency, they vote against us in favor of another political party. So through profiling, through surveillance, we will get to know. If such majority of people who are against the government belong to constituency B, what the governments can do? Gerrymandering. What will they do? A part of these people will be shifted to constituency A. A part will be shifted to constituency C, where we already have the majority. So these people who would at least send one person to the legislature, they won't be able to do that, because by profiling you, by surveillance, by targeted surveillance, we have now implemented gerrymandering, where we know exactly who is our political supporter. So long story short, does right to privacy include right to protect citizens' political affiliation? Yes. But now the second counter question is whether financial contributions to political party, whether is it a facet of this political affiliation, which you can't disclose either. If right to privacy is a fundamental right, donor also has the right to privacy. And now you have agreed that right to privacy includes right to protect my political affiliation. Now the corollary should be, don't even disclose to whom I am donating. Make my financial contributions also a facet of my political affiliations, and don't disclose my identity to which political party I'm donating. The court said for this we need to understand that financial contributions are made for two reasons. Either it is a genuine expression of support, I genuinely support this political party, or it is in the form of quid pro quo, in the form of give and take. Supreme Court said, we can protect this, but we cannot protect this. For that, if you are donating less than 20,000 rupees, we may come to a conclusion that you are donating money to this political party out of your sheer support. This is your expression of support to this political party. But if you are donating more, we may safely assume that there is an element of quid pro quo. There is an element of give and take. Those financial contributions we cannot protect under the garb of right to privacy. The Supreme Court said, right of informational privacy. Information regarding your political affiliation, information regarding your financial contributions to political parties. This is part of right of informational privacy. This right of informational privacy extends to political contributions made to political parties. Is it a facet of political affiliation? For that, we have to prescribe something called double proportionality standard. What is this double proportionality standard? On one hand, we have Article 19(1)(a), which is right to information. Clear? On the other hand, we have Article 21, which talks about right to privacy. On the other hand, we have 19(1)(b). We have 19(1)(c), which basically talks about right of every single citizen of India to assemble peacefully without arms, to express your support for your political party. Right of every single citizen that you can form an association, union, or a cooperative society, which may also mean that you are part of a political party. But unfortunately, Supreme Court says, Constitution does not talk about any hierarchy, that whether right to information will prevail or right to privacy will prevail. What electoral bond scheme does, it protects the informational privacy of a donor. Yes, it does. But at the same time, it violates right of a citizen to know the financial contributions to a political party. In this case, will this prevail or that prevail? That is a $1 million question. And for that, Supreme Court said, let's understand this. Right to privacy of political affiliation does not extend to contributions made to influence policies. If you are donating more than 20,000, you are not donating because of your expression of support. You are donating because of quid pro quo. You are donating because you need something in return. This right of privacy extends to contributions made as a genuine form of political support. If it is genuine form of political support, which we can say is contribution less than 20,000, that will be protected. And that in any case is protected. Because any contribution to a political party, less than 20,000, you don't have to disclose the identity of that donor. Why? Because this is part of informational privacy, which extends to the political affiliation of an individual, which also further extends to the financial contributions made to political party, which is also a facet of political affiliation. But we cannot protect under right to privacy the contributions which you are making to influence policies, because the crores of money that you are donating to political party, it is not because you are expressing support to a political party. It is because you want to influence policies. You want to get into give and take. Get a contract, get a license, get a permit, change policies. Because now you are at the table with political parties to influence their policies and programs. So a contribution less than 20,000 can be protected under the guise of right to privacy, but not contributions more than that. So that is one answer to one question that court had to struggle answer with, which is, does non-disclosure of information on voluntary contributions to political parties violate Article 19(1)(a)? The court said yes. Does right to privacy include the right to protect a citizen's political affiliation? Yes. Whether financial contributions to a political party is a facet of political affiliation? Yes as well as no. Yes, if it is the money which is donated as a genuine form of support, as an expression of support, not as a way of influencing policies, because we need to balance the rights. On one hand, we have right to information, a right of a voter to know the financial contributions to a political party. On the other hand, we have the right of privacy of a donor who wants to protect his political affiliation. How do we balance it? Electoral bond scheme is unconstitutional. Your financial contributions, if less than 20,000, gets protection, but not more than that, because that donation, more than 20,000, most of the times is not an expression of support. It is in relation to quid pro quo. Although the court did agree that sometimes contributions more than 20,000 can also be a genuine expression of support. But by and large, balancing the rights, this electoral bond scheme is unconstitutional. Now the court had to answer second question. Does unlimited corporate donations to political parties by amending the Companies Act violate free and fair elections under Article 14 of the Constitution? What is free and fair election? Anybody who is eligible should be allowed to contest elections, which means the election is fair. But even if you are allowed to contest elections, the outcome should not be rigged. That means the election should be fair as well. Whoever has won should be declared a winner. You cannot switch votes here and there and manipulate the results. Free and fair election, the Supreme Court has said in Indira Gandhi case, is part of the basic structure of the Constitution. And what about Article 14? It talks about right against arbitrariness. Right against arbitrariness is a fundamental right under Article 14. What is this right against arbitrariness? Let me give you one example which I gave my students in the live classes. We started this class at 7 o'clock and the time is 7:59. What if I tell you, whoever has joined this class between 7:30 to 7:45, you can ask me 10 questions. But those who joined right at the start at 7 o'clock, you cannot ask me any question. What is the rationale on the basis of which I'm making this policy? It is illogical. It is arbitrary, without any logic. In contrast, if I would have said, those who belong to engineering background, poor guys, you can ask me 10 questions. But those who are from law background, you can ask me only one question, which means I am discriminating between two set of people, between two classes of students. But this classification is not arbitrary. This classification is based on sound reasoning, because a law student need not know everything that I'm talking about. Maybe he just needs to understand one critical point or to clear one sort of confusion. But the engineering student who studies one night before the exam in his engineering class, he requires proper guidance. On one hand, we are talking about companies, and is there a limit to the amount of money that can be donated by an individual to a political party? No. There is no limit. You can donate whatever you want to donate. There was a limit under the Companies Act that this company, it cannot be a government company. It cannot be a loss-making company. It can be a company which has made profit in the last 3 years, 3 financial years, and 7.5% of the aggregate profit, they can donate money to a political party, not more than that. There is a limit. The government said, we want to treat them equally by reducing or eliminating the limit for the companies as well, by treating individuals and companies alike. The Supreme Court said this is manifestly arbitrary, violates Article 14, which talks about right against arbitrariness. Why? The Supreme Court said the potential of a company to influence policies of the government is much, much more than the influence which can be imposed on political parties by individuals. So by equating and by treating individuals and companies alike, you're violating Article 14, which is right against arbitrariness. Why government companies were not allowed to donate money to political parties? Because then it would have allowed these government companies to participate in politics. They would have donated money to the ruling political party. It would have tilted the scales in favor of the ruling political party. Free and fair elections would have been violated. And now what you're doing? You are allowing loss-making companies to donate money to political parties. You have removed the cap on political donations, which basically means you're allowing loss-making companies to donate money to political parties. Why on earth would a loss-making company donate money to a political party if it is not for quid pro quo? If it is not that I will donate money to you right now, although I don't have money, although I am almost bankrupt, although I am loss-making, but if I donate money to you, you come to political party, make policies and programs that will favor my company. Give me contracts, give me permits, give me licenses. And this will tilt the scales, will violate free and fair election, which is part of the basic structure of the Constitution. This principle is violative of the principle of free and fair elections. And as such, it is unconstitutional. So the electoral bond scheme is unconstitutional because it violates citizens' right to know. Yes, the donor has a right to privacy, but we need to balance these two rights. Electoral bond scheme, it gives me protection. My informational privacy is protected. But when you say you can't disclose the identity of this donor at all, this carte blanche, this outright negation of accountability, this would violate citizens' right to know because we have to balance these rights. As such, electoral bonds is unconstitutional. And this amendment to Companies Act, which allows loss-making companies, which removes the limit to the amount of money that can be donated to political parties, it is also unconstitutional because it violates Article 14, it violates free and fair election, which is part of the basic structure of the Constitution. And Supreme Court issued directions. Supreme Court issued direction saying State Bank of India stop the sale of all electoral bonds. Election Commission of India, get the details of which political party got donation from which individual. Tell me the name of the donor. Display it. Display the quantum of the donation. And all the political parties, if you have received electoral bonds but you have not encashed it, give it back to State Bank of India. State Bank of India give it back to the purchaser. Refund it to the purchaser. That is what a 5-judge bench of the Supreme Court ruled today in this landmark, historic Association for Democratic Reforms versus Union of India. But the sad part is, it took 6 long years for the Supreme Court to reach to a conclusion. By this time, Lok Sabha election was also conducted. Multiple state elections were conducted. And it's not that somebody did not approach the Supreme Court. The moment the scheme was launched, even before notification of the scheme was challenged in the court. Initially, court refused to hear this matter. After a few years, the court heard this matter. And the court said, since the scheme has been in operation for more than 2 years, let's not impose a stay on electoral bonds. Let the electoral bonds continue to be sold. Because the petitioners asked, please impose a stay because this is blatantly unconstitutional. But the court said, since this scheme is in place for the last 2.5 years, let the scheme continue. It was in place because you did not hear it. The former Chief Justice of India was also asked, why did you not hear this case? When he was entering the parliament, he said, I don't remember about this case. It speaks volumes about the role of the Supreme Court to immediately impose a stay on contentious issues which prima facie blatantly violate the Constitution. Because all the elections which have been conducted since the launch of the electoral bonds, maybe electoral bonds vitiated those elections, violated the free and fair elections, violated the level playing field in the elections, and the courts did not come to the rescue. By not hearing this case for 6 long years, by not deciding this case for 6 long years, the allegation against the judiciary is that it is practicing something called judicial evasion, where judiciary is evading verdicts on important issues, sensitive issues. By evading, it is basically favoring the ruling dispensation, the ruling political party. Because the biggest beneficiary of the electoral bond scheme is the ruling political party. And it is not just about this particular ruling party. Tomorrow the governments may change. Any scheme which is tilted in favor of the ruling party violates free and fair elections. And it is the principal purpose of the judiciary to uphold democratic values, constitutional values, and at least impose a stay on those issues which at the face of it, prima facie, are blatantly unconstitutional, and not wait for 6 long years to pronounce the validity of such an important piece of scheme which affects free and fair elections. That is it for today in our first episode of The Nuanced, an initiative where we present a nuanced explanation of critical topics, complex topics. If you have liked the session, do not leave before pressing the like button, and subscribe to our channel if you haven't yet, and share the links of these classes with your friends and fellow aspirants. Thank you for watching. Good night.